In this video, we're going to be exploring the orthodox or classic view of parliamentary sovereignty a bit more closely. Let's get started. Hi everyone, in this video I want to explore a little bit more closely the orthodox or classic view of parliamentary sovereignty. And what I want to do is consider some quite dramatic implications of that particular view of parliamentary sovereignty that I think haven't been fully explored, fully ventilated in the literature thus far. We looked at the orthodox view of parliamentary sovereignty in an earlier video. There's a link in the description. And it's the view associated with Dicey, according to which Parliament is legally unlimited in its power to legislate. Parliament is legally omnipotent. And one feature of this view is that each new Parliament enjoys this legally unlimited power to legislate. And if there are earlier acts of Parliament that attempt to impose constraints on the current Parliament, well, those won't be effective because each new Parliament is legally omnipotent, is free to legislate however it wishes, and is not bound by any constraints that an earlier Parliament might try to impose. Of course, we should also add that each new Parliament, according to this view, is perfectly capable of amending any earlier Act of Parliament, of repealing any earlier Act of Parliament. All of these things are perfectly possible for each new Parliament. Now, here's an interesting thought. What if Parliament, the latest Parliament, the current Parliament, decides that it's going to do something quite dramatic with regard to the existing statute book? Suppose that the latest Parliament decides that it's going to rearrange, reorder the priority relations between earlier acts of Parliament. What does this mean? I'll give you an example. So suppose that Parliament, the current Parliament, decides that in relation to the existing body of statutory law, those statutes that are concerned with and are seeking to further national security interests have priority over any statutes, any existing statutes that are concerned with data privacy. This is a common issue in the law. Security and intelligence services are interested in collecting data, information as much as possible relating to possible threats. And that might mean that they are gathering information concerning telephone records, location tracking, and so on. And that, of course, can rub up against various rules protecting our privacy. In the scenario that we're thinking about, Parliament, the current Parliament, has decided that it's going to privilege the furthering of national security interests as against the protection of data privacy. And so what Parliament does is it enacts a statute, the current Parliament enacts a statute which provides that in relation to the earlier body of statutory law, those enactments that promote national security have priority over those that protect data privacy, and regardless of when those earlier statutes were enacted. So to fill this example out a bit further, what this might mean is that you could have an Act of Parliament from 1980 that is furthering national security interests, and you have an Act of Parliament from 2010 that is furthering data privacy. And according to this new statute that has been adopted by the current Parliament of 2021, the 1980 national security related statute should have priority over and should take effect in preference to the 2010 statute concerning data privacy. So we would have a potentially, let's say, a conflict that might emerge between the 1980 statute and the 2010 statute, and yet the courts are being instructed to give effect to the 1980 statute in preference to the 2010 statute protecting data privacy. And here's the interesting thing. All of this may be compatible with the orthodox Dicey understanding of parliamentary sovereignty. Why? Because all of this is taking place because of what is required by the latest Act of Parliament, the 2021 statute. And so all the courts are doing is giving effect to the latest expression of Parliament's will, even if that means that what the courts ultimately are tasked with is reordering the priority relations between earlier statutes, regardless of their date of enactment. So I think there are a number of interesting things about this, and I've written a paper that discusses some of these issues. The link is in the description. One interesting point here is this just demonstrates the power that Parliament has vis-a-vis the existing statute book. We know that Parliament can amend and repeal existing statutes as it chooses. But in addition, Parliament has this power to rearrange the relations between existing statutes, between existing classes of statutes, for instance, those furthering national security versus those furthering data privacy. So these are all things that a legally omnipotent Parliament seems to be able to do, according to the orthodox Dicey understanding of parliamentary sovereignty. Another interesting point that this throws up is that it helps us clarify, I think, what the orthodox view of parliamentary sovereignty really is, how we should understand it, how we should describe it. You sometimes see in the literature and in the case law a suggestion that, according to the orthodox Dicey understanding of parliamentary sovereignty, where there is a conflict between two acts of parliament, an earlier act of parliament and a later act of parliament, then, according to the orthodox understanding, it's the later act of parliament that prevails, it has priority, and the earlier act of parliament has to give way. Now, what I think is interesting about this scenario that we've been thinking about is that it suggests that this sort of understanding of the orthodox view of parliamentary sovereignty might not be entirely reliable, because in our scenario, we can imagine the current parliament, the latest parliament, adopting a statute which is reordering the priority relations between earlier statutes and requiring that some of these earlier statutes have priority over other earlier statutes, and regardless of their enactment dates. If one is sympathetic to the orthodox view of parliamentary sovereignty, maybe the better view, perhaps, is not the view that if there is a conflict between two acts of parliament, it's the later act of parliament that takes priority. That may often be true, but may not always be true. The better view, I suggest, might be that, according to the orthodox view of parliamentary sovereignty, the courts are striving to give effect to the latest enactment of Parliament. That is probably the key proposition that is to be associated with the orthodox view. And that helps explain this scenario that we've been thinking about. The courts will give effect to the latest enactment, the latest act of Parliament, including where that act of Parliament instructs the courts to reorder the priority relations between earlier statutes. So this scenario that we've been discussing is, I think, interesting for us and useful for us in clarifying what is really going on with the orthodox view of parliamentary sovereignty and actually what might be possible according to that view. Parliament can do all sorts of things with regard to the existing statute book. Some of these aspects may have been somewhat neglected or overlooked. A final point to think about is why. Why might Parliament intervene in this way vis-a-vis the existing statute book and decide that some statutes dealing with a certain subject matter should have priority over other existing statutes? Why might Parliament want to do this? And should it be doing this? Should we be worried about Parliament doing this? These are, I think, some of the pressing questions that we should be thinking about moving forward. What's prompted me to actually pay attention to this myself is some of the legislation that Parliament has enacted concerning the UK's withdrawal from the European Union. And one item of legislation, the European Union Withdrawal Act 2018, is doing some quite interesting things with regard to the pre-existing law and prompts these sorts of questions about what Parliament can actually do vis-a-vis the existing body of law, the existing statute book. Again, I talk about that a little bit more in the paper that I've put together. But I think this is interesting. I think what this shows is that even with a view of parliamentary sovereignty that we thought was quite settled and quite well understood, the orthodox Diceyan view of parliamentary sovereignty, actually there are some hidden crevices and avenues for exploration here that require our attention. Let me know what you guys think about this, whether you're persuaded by any of this, whether you reject it out of hand. Feel free to drop a comment below. Thank you very much for watching and take care.